Our program this evening is dealing with the state's new laws when it comes to conflict of interest scenarios for boards of directors of co-ops and condos. Our speaker is no stranger to the membership of the CCAC and of course the membership of the BRI. He is Daniel Finger. He is an attorney with Finger & Finger, a professional corporation which serves as chief counsel to the CCAC and the BRI. Dan has spoken at several of our membership meetings in the past. He is one of our referral attorneys that you can call if you have a question or situation involving your complex. And he also contributes a bi-monthly column to our bi-monthly publication, Impact newspaper. Ladies and gentlemen, please welcome Daniel Finger.
Good evening, everyone. I'm not quite as tall as Jeff, so I'll lower this a little bit. Good evening, everyone. Everybody hear me?
There you go.
Okay. I'm going to talk tonight on the new conflicts of interest law. I'm going to try and not make this too much like a law lecture, but unfortunately, since we're dealing with the law, that's kind of inevitable. I put a handout, there was a handout when you came in, I put a kind of abbreviated version of that on the tables that has the text of the statute and some other forms that I'll discuss in a minute. The interesting thing is part of this existed, the BCL, the Business Corporation Law, which is what governs cooperatives, Section 713 has already been in existence. So part of this is actually not new, part of it is new. I'm going to go over the existing portion first and some of what's the way business has been done. The other interesting thing about Section 713 is that does not, there's a little bit of a quirk here because Section 713 doesn't actually apply to condominiums. I think that's something that the legislature will probably rectify at some point. And that's not to say that it's not a good idea to, practice that anyway. 727 does refer, which is the new section, 727, that does refer to condominiums. So there's a little bit of a conflict in the conflict law. But again, I think the legislature will probably at some point rectify that. So under 713, the existing law, we've always basically advised people is the boards have to disclose any business relationships, any businesses with whom they have a relationship who may also be seeking to do business with a co-op or condo. So that could be a variety of different areas, whether you as a board member in your day-to-day job happen to be a service provider, it could be anything, a contractor. A common one also would be real estate brokers. Boards get involved in situations where they either for whatever reason maybe foreclose on a unit or somehow or other have a unit that they want to sell, and then a board member who happens to be a real estate broker wants to be the broker to list that unit, so that it could be that's a very common place it could arise. So this is not one of those theoretical, or abstract things that doesn't really happen. As you all know, board members are real people. You all have jobs, so these things could come up. And the interested board members, if you have a relationship, you need to disclose it, and then especially now. We've always advised board members that are interested board members not to participate in discussions that revolve around a situation where they are interested, where they're that interested party in the business that's going to result from whether it's a contract being awarded or a brokerage commission. We advise the board members not to participate in those discussions and not to vote on any votes that are going to be taken for those contracts. The statute already provides guidelines as to the possible remedies in the event there are conflict, but the existence of a conflict alone, due to that financial interest or that board member being interested, does not make the contract void or voidable for those reasons alone. I'll get into that again in a minute. And also, just because a board member happens to be present and votes on that transaction, that also doesn't automatically void the transaction, especially if there is sufficient vote without that director's vote, or there's or whoever the remaining people, if it was unanimous with all the remaining people, that also wouldn't automatically be voidable. In the event, contracts also, there are certain situations where you could have a contractor, if you weren't sure, you could have it approved by the shareholders. And as long as the financial interest was disclosed, again, then the contract is not automatically voidable. If it's not approved in accordance with those provisions, the disclosure, the contract might be voided unless the parties can establish that the contract was fair and reasonable to the corporation at the time it was approved. The goal, now that's all basically in section 713, the existing statute. The new statute, 727, the goal was to codify this and ensure compliance. Under the new law, at least once a year, every director is supposed to be given a copy of section 713 of the BCL. So that's included in what I put on the table, so now you all have a copy of that statute. But that should be given to each board member annually. You should also have the board members sign a receipt indicating that they've received it. In addition, under the new law, you need to do an annual report listing all contracts or transactions that were voted on by the board that involved an interested director, and that has to be signed by all the directors and sent to the shareholders. Probably the best practice for that is to do that around the time of your annual meeting, include it with what you're sending out to your annual meeting. That way it becomes a regular practice. Then it's being done annually if you're always doing it around that time of year, and with that, the notice that you're sending out. Annual meeting, you're sending out your annual meeting notice, other forms with that, just include this as part of it. Or if you send out your financials at some point, you can include it as part of that packet. But as long as you have a regular time when you're doing it, so you don't forget. The report has to contain certain things, has to contain the detailed information regarding if there are any contracts, has to have detailed information regarding the contractor, the significant terms of the contract, the amount of, including the work performed, and the amount of the contract, and the date of the contract, and the date of completion or expected completion of the work. It also has to list the meetings of the board of directors where it was discussed and voted on, and how each director voted. And then also the date of the vote and the date that the contract was effective as of. Those dates could be slightly different depending on the type of work or the nature of the work. If it's a contractor, that's one thing, you might have an end date. If it's a service provider, it might start on a date and it might be for a longer period of time, similarly with a brokerage type of agreement. In the event that there are no contracts involving an interested director, then all of the directors have to sign a disclosure which states that no actions were taken by the board that were subject to the annual report requirement pursuant to section 727. And you have to send those notices to all of the shareholders. As I said, sending it with your annual meeting is just procedurally a good way to do it, whether it's your annual meeting or financials. Sometimes you're doing it regularly. That way you're going to be in compliance. The goal of the statute was to increase transparency between the board and the shareholders. And one other issue with the statute is it doesn't provide for any enforcement procedures. It gives the members the information, the basis, if there are any violations, but there's not really any way of enforcing it. There's no penalty, specifically in the statute if you don't comply. Which is not to say that somebody might not bring a litigation. I'm sure there probably will be some litigations that will result from this, and then we'll find out, what the damages are, and what effect it'll have on the contract. There have been situations already where courts have held that contracts were not valid because it didn't comply with 713. So just putting aside 727, under the old law, there's been cases, and I have one that had to do with a real estate brokerage type situation, like I mentioned, where the court held exactly that it was that they didn't comply with those requirements, and so the particular board member wasn't entitled to a the commission split that he was seeking. And if you look at the handout that I provided, there's 3 documents. The first is the first is the statute, I guess 4 documents. But turning the page, then there's the report, that's our form of the report that we've sent around to a lot of our clients that says that there was no contracts by any interested directors for that year. And you would have each of the board members sign it and date it. The next form is the form you would use in a specific instance if there is a contract or situation where there is a conflict that the board was approving. That's the form that you would use to set out the details of that particular conflict and that transaction. And then the last document is the disclosure report that you would use in the event that you have a year where there are specific conflicts of conflicts of this nature. Anybody have any questions?
Dan, do you think that the statute is applicable to HOAs? Homeowners associations seem to be exempt and excluded from the parlance as condos, but I have advised all my HOAs to attempt to adhere to it as well.
Yeah, I mean, I think it's like I said with the condominiums, it's a quirk, but I would agree that I would advise, just like condominiums, that you should adhere to it. There's really no percentage in putting yourself, you're an HOA, putting yourself in a situation where you're hiding something. If you're going to approve it, if it's a fair contract, you have nothing to hide. There's nothing wrong with disclosing it. And I mean, largely the books and records are usually the unit owners or the members can examine them anyway. So they would, if they really wanted to, they could find out in any event. Jason?
Yeah, not having fully read this statute, I assume a conflict of interest would also include where a board member may not have a direct relationship or ownership interest with a contractor or a service provider, but if a particular contractor or service provider gets hired and there's a, for lack of a better term, a kickback back to a board member because the contractor was a friend or something like that, how does that relate to this?
I mean, that's a little different. That's, I would advise against that for different reasons. Kickbacks. I mean, I think it becomes a conflict. It's a different type of conflict because it's not the direct financial interest. The issue that this statute is trying to address is situations where the board member is a financially interested party in that entity, or it could be themselves. It could be as an individual.
It's more common.
What?
I bet my scenario is more common.
Your scenario probably is more common, and I think there's probably other statutes that if I had to do the research that I could probably find that would address that and would say that's not a good idea, but it's not exactly directly related to this. Caesar?
Is there any kind of similar ethics similar to this for property managers, which generally speaking, I don't know how other people do it, but you're going to do a job, the property manager goes, gets 3 or 4 guys and do the bidding. His to disclose his property.
I mean, that's different. That's between the building or the property and the property manager. Typically, most property managers, they'll just, if they're going to act as a real estate broker, you're going to be aware of it. I mean, it's under their same umbrella, so you would presumably know about it. But that would depend on what you're...
You need a sideboard, 100 feet of sideboard, you're going to get 3 guys to bid on it.
Right.
The property manager should, without any legislation, tell you if he has an interest in one of those contracts.
He should. This doesn't address property managers. This addresses board members. I mean, the property manager is an independent company that you're hiring. I'm not aware of similar legislation. In fact, are you, Ron?
Dan, one of the major issues that we've discussed with our boards is getting a conflict letter from your superintendent. He's a referral source. In big contracts, when the managing agent gives you whatever they recommend, we always have a representation from the contractor that there was no improper compensation. We call it the kickback representation, that they were not required to pay anything or anything else. one of the interesting aspects of this is, forget the monetary benefit. If it's just your friend, my brother can provide this service. I'm not getting any money, he'll do it for a reduced price. I think if it doesn't pass the smell test, everything needs to pass the smell test as a board member. If it doesn't pass the smell test, if it's too close in contact with a board member, it's better to avoid it, it's better to avert the problems. We now have shareholders and unit owners who are very interested in disclosure. Recent cases have allowed them to really do a colonoscopy on your board minutes, so be careful.
Yeah, and I think that's a good point, well said, that, you know, the idea is, you know, this law sets out some specific things, but this is not the end of the road. This is not, it doesn't mean that if it's not specifically mentioned, whether it's HOAs, condominiums, you know, in the existing law, the now new law, right, there are certain things that are the spirit that are gonna be a problem anyway, and, you know, it's, as Ron said, you know, just be smart about it. You know, this is addressing the board members specifically, but that doesn't mean that, you know, the property manager, the super, you know, whoever it is, I mean, they got to be smart, and the board should, you know, if they have to, ask the questions.
Mary?
So with the, excuse me, with the new law, is this saying that we have to do this now for 2017? Or at the end of 2018, we have to present this to the shareholders?
Well, you should do it, you should pick a date. I mean, you should do it whenever your annual meeting is going to be, do it as of the annual meeting. You should start keeping track now, so that if a conflict arises, you know, then you use the form. And then whenever it is that your annual meeting happens, you know, I would do it then. That way you don't have to worry about, you know, just make it part of the regular habit and part of that annual meeting procedure, that with that annual meeting notice, you're going to send out that report to the shareholders or unit owners. That way, you know, and it'll be done every annual meeting every year. That way you know you don't miss a year, because that's part of your regular procedure. And you tell the managing agent that you want them to put it in their procedure, that, you know, that they're going to bring to the meeting before the annual meeting, so you can all sign off on it, and then they're going to send that out with the annual meeting notice. They'll send out that disclosure to the shareholders.
Thank you.
Story.
I have a question. Normally our annual meeting is in June, so if we're keeping track of January 1st. We don't have to do it for the calendar year, just every June we can give it out to the
Right, I would do it every June. It doesn't specifically say that you have to do it every January 1st, so yeah.
Perfect. Thank
Only for the first year.
Big contract.
Yeah, but Peg's got a good point, if I don't forget it. So there's no enforcement. Who's monitoring it?
I mean, that's the issue. There's no enforcement. But, you know,
No monitoring, no due date.
the shareholders are, you're monitoring it, you're having the managing agent monitor it. I mean, you're taking charge, because the problem is there's no specific enforcement, but it's possible that a shareholder, or, you know, maybe one board member that didn't like what happened, you know, that they could bring a suit against the co-op or condominium, and then, you know, find out exactly how it's going to play out and what the court thinks, you know, about this situation. You know, there's a rule, the rule was violated. Does that mean that the contract is void or not? You know, that it could mean that. The court could decide that that's good enough to say that if they didn't follow the disclosure procedures, that the contract should be voided.
What if the contractor doesn't want you to void the contract?
Well, look, like I said before, it's not automatic. It's if you can show, if the parties, if the board and the contract can show that, it might not be up to the contractor. He could, I mean, look, we're talking about hypothetical litigation, and I guess hypothetically he could intervene and he could have his own point of view. But the standard is usually that if the parties, if the board and the contractor can show that the contract was fair to the property, that it wasn't, you know, that it wasn't inherent, that it wasn't unfair, then it can be, you know, kind of ratified, for lack of a better term, anyway.
Anyone else? Sandra Alaska.
I'm vice president of my board. I'm also chairman of the admissions committee. My husband is a licensed realtor. If he sells and represents either a buyer or a seller in our building, then that person has to come before the interview committee. As long as I recuse myself and have nothing to do with it, all I have to do is sign the first form.
Well, yeah, yes, but the situation is really a little different. I mean, yeah, I would recuse yourself, and then you can identify it. The bigger issue would come into play where if the board foreclosed on a unit and they were deciding what real estate broker to use to sell their unit, and the board decided to retain your husband, that would be this type of conflict of interest. That would clearly be this type of conflict of interest, because you would be getting monetary compensation from the board as a seller, as opposed to, it's a little more indirect when, there's a buyer seller, you happen to be your husband happens to be representing. I think it's still probably, I would adhere to this. It's just safe, and I don't think anybody would question it. And obviously your husband's trying to get the best deal that he can and represent his clients as best he can. So that kind of falls a little more into the better safe than sorry. But like I said, I think the better example is if it was the board owned the unit that they were trying to sell, because then the board, then the co-op or condo is actually paying to you and your husband, that commission. Well, you'd be a better, but, right.
Carl, did you ever talk about the doctrine of corporate opportunity, where if you are a board member and an opportunity you learn about being a board member, like buying a foreclosed unit, but all the other shareholders don't know about it, or you come across something, you have a duty, I believe, under your fiduciary duties, to disclose these things to the board, and you should tell your board, I'm thinking of buying this unit. I think it's a great buy. I think you have a duty to offer it to the board first before you take that opportunity, because you serve in a fiduciary capacity, and that doctrine should apply to you first offering it to the co-op, that it's something that you've learned in the scope of work or knowledge that you've acquired as being a board member.
Yeah, no, it's slightly off topic, but I agree. Yeah. Any other questions? Thank you.
Thank you, Dan, another solid job. If you did not get your parking stub validated, please see me before you leave this evening. This way you will avoid a parking charge. Once again, many thanks to Dan Finger of Finger and Finger, and many thanks to all of you for attending this evening's program. You'll hear from us in the days ahead on future programs. Have a great evening and a safe drive home.